Good morning, everybody. It is now 10 o'clock, and I'm told that there's, yes. Well, that was suitably short and brief and to the point. It's good morning again, everybody. It's good to be back in Godalming, and I'm sorry it's taken quite a while to arrange the resumption of the inquiry, which, as you'll no doubt recall, was adjourned on the opening day back on the 12th of November last year. Just a very quick reminder, this is an inquiry into 4 appeals, all for traveller sites, appeals A, B, C and D, all at land north of Lydia Park at Stovolds Hill, Cranley. My name is Richard Clegg. I'm a Chartered Town Planner and I've been appointed to determine these appeals. A reminder that the inquiry is being live streamed. So the important thing is although you may be able to be heard in this room, you need to have your microphones on all the time to make sure that the streaming picks them up. And I'm told it can only be one microphone at a time. So when there's exchanges between parties, I'm afraid you're going to have to switch on and off so that we don't get feedback and problems from those who are trying to follow the proceedings. The usual reminder about phones, please do have them on silent so that we're not interrupted. Other housekeeping points, toilet facilities down the corridor along the way that you came in on the left-hand side. If that alarm goes again, it's obviously the real thing as we've had the test. Follow the signs down to reception and then proceed out of the building. And I think the next thing I want to check, given the length of the adjournment today, I just want to review the appearances so I'm absolutely certain who's attending and there have been no changes during the interim. Mr. Masters, can I start with you because you're representing most of the appellants?
So it's the same. I'm instructed by Brilliance for one and Mr. Rowe the other two.
So let me just get this right. So it's Brilliance Solicitors, isn't it?
It is.
And am I right in thinking that's Appeal A? And then you're doing C and D as well? Yeah.
Mr. Rowe isn't here today. So something else.
Right, okay. But he's instructing you on C and D?
Yeah. I said to him that with various issues, he couldn't be here, so.
Okay.
And it's a little bit more complicated because in relation to Appeal A, my planning witness is Mr. Woods.
Well, I want to come to that, and you hopefully you've received an email from the office about that.
I'm sorry, sir, I probably can't.
Well, it's okay. Well, I'll raise it when I. But in terms of appearances, as far as your clients are concerned, Mr. Masters, you've told me your instructions. My note last time was that you had Mr. Rowe down as a witness, and then 3 appellants, Mrs. Doherty, Mr. Doherty for C, and Mr. Doherty for D.
Yeah.
Is that right? No changes there. Good, thanks. Mr. Cottle.
Yes, still representing Mr. Simon Doherty.
Yeah.
And calling Mr. Woods.
Sorry?
Calling Mr. Woods, Brian Woods.
Yes, yeah. And that's as it was.
That's right.
Yeah. Good. Thanks, Mr. Cottle. And for the local authority, it's Mr. Lintott, isn't it?
It is indeed, Inspector, yes. So, and no change in respect of who we're calling.
You're doing A, C and D, and Mr. Cottle's doing B.
Yes.
So you've got 3 lots of appellants.
I thought my own notes said B, but I can see that B is actually Simon, and I thought that was Thomas.
It's definitely A, yeah.
I'm sorry.
That's all right, don't worry. It's important that we get that right. And I'm just saying, Inspector, that there's no change from our side, as you would expect.
Right, so just to recap then, you've got,
So we've
my
got,
note says you've got five witnesses, Mr. Sibbott, Mr. Smythe, Mr. Dudley,
Yeah.
Mr. Jarman and Mr. Ward.
you've got it, absolutely.
Good, thank you. And then let me just check on the other parties, the interested parties. The parish councils had all previously expressed a wish to speak. We heard from Councillor Britton from Oldfold Parish Council on the last occasion, and I had a note that representatives of the other three parishes, Bramley, Dunsfold and Hascombe, all wish to appear. Can I just check whether there are representatives of those parishes here? So Councillor, so is it Stern or Stoke? Stern, yes, you're here. Good. Yeah. Good. Yeah. Right, thank you. Is Councillor Britton here from Oldfold? You're here as well. Good. Now the only evidence we heard last time was from Councillor Britton before the inquiry was adjourned. All the parties have put in, given the length of time of the adjournment, supplementary evidence during the interim period. And clearly the other interested parties will have the opportunity to speak to that when it's their turn to give evidence. So my intention was to, if it was relevant to Oldfield's case, Councillor Britton, to ask if you wanted the opportunity to give an update on your evidence. It's entirely up to you, but I just wondered if you wanted that opportunity.
Don't have anything material.
That's fine, because yeah, I mean you've given your evidence. We've noted you've been examined on it, and I've got a note. That's fine. Okay, I've been through my note of the parties I was aware of previously. Is there anybody else in the room who wishes to speak at the inquiry? Yeah. I will check again before the end whether there is anybody else who does wish to take that opportunity. Now there's few outstanding things. Firstly, in terms of the locations, how sites C and D, Mr. Masters, should be identified. I think I raised this when the inquiry actually opened because it wasn't entirely clear from what was given. This was something that was raised at as long ago as the case management conference. And I think in terms of, actually I think Mr. Cotler, it also affects you in terms of site B. I don't think we've got a definitive view yet on.
I'm conscious of this and I was raising questions about it.
Yes.
And we don't have a plan in response to your request, which you made at the opening, for the exact locations. But as I understand it from the local planning authority, there isn't any difficulty as regards their handling of their case in relation to their understanding of where our site is located. But I do acknowledge that there is this gap in the evidence because I think it's probably most relevant in relation to flooding as to where the exact boundary is.
That's a slightly different point, perhaps a more potentially a more serious one. At the moment, I want to know how the site should be referred to. We've got C and D are quite clear. Their plots 4 and 3 respectively on site 1 at land north of Lidgy Park. And the furthest the agreement got on the others was that there should be reference to land north of Lidgy Park. So I was looking for something more specific, and I really want progress made on that.
I understand your concern now, yes.
But on the point, I was going to come to the plans, but let's deal with it now.
So I understand specifically what you want, and then I can go and get instructions and have something done. Are you meaning in terms?
Of the form of words which says where the site is. Well, let's come to the point that Mr. Cottle's raised in a moment. Yes, form of words. For example, it was agreed at the case management conference that site C, which is one of yours, Mr. Masters, is plot 4 on site 1, land north of Lidger Park. And there's a similar form of words to describe the location of site D. But there wasn't such a form of words agreed for A and B. That was outstanding from the case management conference.
If I could just step in here, I mean, from the history, it seems that there was a planning application in relation to what is now Appeal C and D that failed, and there's the longer history, and everybody's understood from the High Court proceedings where those plots were very, very clearly marked out. Because Mr. Simon Doherty arrived, so to speak, later on the scene, and Thomas Doherty too, there isn't that same clarity.
Okay. Well, whatever the reason in terms of the background and the history, Mr. Cottle, we need to get some agreement, and it did seem to make sense, and it was agreed at the case management conference that there's a common point in the location, that they're all north of Lidger Park, and that would be included.
Understanding what you said, sorry, this is a point that I haven't looked at, so I'm probably a little bit of pressure. But I thought you just said that there's no issue with Matthew document because his description has been identified. I think this will for site 1 landlord of the park.
Mr. Matthew Doherty is appellant D, isn't he? So, plot 3.
Plot 3.
Plot 3, site 1.
Site 1. Could we not therefore say in terms of
Well,
the leader that would be plot 4 site landlord?
well, rather than it's perhaps a bit too detailed to try and resolve
like in writing
in the formal inquiry session. I think perhaps you and Mr. Cottle need to get an understanding of what you're looking for and have a word with the local authority as well, and then come back to me later today.
I think in relation to Thomas, he won't be plot 4, will be this site is in a different location.
Well, he's one of the ones that
Yes.
he's A, so he's one of the ones that I'm not sure about. Okay, but leave that. But I don't want to forget about that point. So that's the. But in terms of the plans, the point that Mr. Cottle's just raised, I think there are two issues. Mr. Rowe, Mr. Masters, submitted plans during the adjournment a couple of months ago, which were addressing the point, but in relation to appeals C and D. And they came in on the 11th of March. I think they've been copied to all parties, so the local planning authority should have these. They essentially reflect a composite plan that was produced by the local planning authority as part of its evidence. And I just want to check whether in terms of C and D, we now have location plans that everybody is content with.
For the local authorities part, we've dealt with that in our
I thought you said you were happy.
supplemental, and we're happy, yeah.
Yes. And presumably, Mr. Masters, as they came from,
We're happy.
you're happy. Yes. So we're okay with C and D.
Yeah. Which is why I'm a little bit confused. The identification point, but it relates to the description.
That point is yes. Now, I think Mr. Cottle, in terms of your point, this I think this relates to appeal this relates to Appeal B and exactly where it was.
That's right. So we'll have a discussion with my own friend. I did raise it with him beforehand to find out if they were in any difficulty. But I do understand that from your purposes, you need a precise identification of the plot of land.
Yes. Now, the local planning authorities put its interpretation on this composite map. And I presume that's what your claim is, Linton, that that's your understanding of it.
That's our
And that's what was
understanding.
considered by the local planning authority.
Yep.
So hang on, Mr. Masters. That's the basis on which I've been working.
Well, we'll certainly come back to this as soon as we can.
I think, yeah, it needs to be as soon as you can, because if there is any difficulty, if there's anything that's at all material in terms of its location, of course, it raises questions about what people were aware of, what the council were aware of when they were considering the proposal. Yeah. Yeah. Okay.
From recollection, I haven't got it right in front of me, there was a site location plan in 1778.
Yes.
Which has never been queried as top secret.
Yeah. I think it's when you compare the different plans and where they are. There's always, anyway, come back to it over I think perhaps first thing this afternoon, Mr. Master, when you and Mr. Cottle have had a chance to look at the plans that were put in initially, look at what the local planning authority says it considered and understood in terms of the description, and then we can hopefully get a clear understanding of exactly what land is at issue. Okay. Just next thing, just to let you know, you may have already seen this on the council's website, that the council did give notification of the resumption of the inquiry. That, as I say, is on the website. I think the only thing I couldn't see on the website, maybe I was looking in the wrong place, is I've seen the site notice, I've seen the letter to interested parties. I haven't seen a distribution list, so I know which interested parties the letter went to. So, yeah, if I could have a copy of that, that'd be great. Good. Next thing, word about procedure. I think either Mr. Cottle or Mr. Masters has already anticipated this. You'll recall at the case management conference, it was agreed that the inquiry would proceed largely on a topic basis with conventional inquiry sessions of examination, but that first of all, there'd be a roundtable on general need for gypsy and traveller accommodation and also on possible conditions. And that did raise the question, which I mentioned on the opening day of the inquiry, about how we would deal with evidence presented by Mr. Woods, because he represents, it's a very unusual situation. He represents two of the appellants in appeals A and B, but there are different advocates involved. I said last time, my position remains the same, that I don't think it would be appropriate for Mr. Woods to be examined in chief twice. And the office did send an email or a letter out to the parties asking for their views on how we should deal with this situation. Now, as we're, I think a suggestion in the email was that as the inquiry is proceeding on a topics basis, and as Mr. Woods has divided his proof helpfully into those topic areas on solution, and I think he's down, as I recall, to appear on 4 topics. There's planning, ecology, landscape and flood risk. And one way forward might be for Mr. Masters and Mr. Cottle to call him twice each. Now, I'm grateful for your comments.
We don't want to be examining in chief, duplicating both of us over the same subjects, and we'll avoid that. I'll have a discussion with Mr. Masters over landscaping, flooding and ecology, and we'll divide it up accordingly.
Mr. Masters, you're happy with that? Perhaps not happy.
I am sorry.
My point's more substantial than that, Mr. Masters. You may not intend to duplicate, but if, for example, when we get to the landscape section, which I think is coming up fairly early, I don't want, when you say you're not going to duplicate, I don't want you asking questions and trying to avoid areas of landscape that Mr. Cottle's asked questions about. I just don't want you dealing with it if Mr. Cottle's dealing with landscape. Do you understand where I'm coming from?
I do so, but for instance, on the issue of need.
Well, needs are rather different because we're on a round table session.
Yeah.
So there won't be any examination in any event, so it doesn't arise.
We have asked in relation to the issue of need, that evidence is taken on that.
I know you have. It's in the proof, but we're in a round table when evidence and oath wouldn't really be appropriate.
Well, I'm a little bit concerned with that, so because of course there is the long delay GTA. We're concerned whether
Yes.
but anything said is on there. So it's we've had experience of this before where things have been said and then after the very process, GTA is then suddenly issued.
Well, all that's dealt with in the documentation that's before me. Is statements from both sides about that. I think need, whether it's housing need or traveller need for accommodation, I don't think it's often a very fruitful process to have examination and great detail on individual sites. I'd much rather have it dealt with in terms of a round table, and that's the way I want to proceed.
I'm not querying that, so I'm not going against what was said. Could we? Well, we'll leave it. So you've got my concern.
Yes, I've noted what you've said. I've noted what Mr. Wood said in his proof. But yeah, it's a round table, Mr. Masters.
But Inspector, on your
Mr. Lintott, yes.
yeah, on your substantive point, which obviously related to those matters that aren't by round table, I think what Mr. Cottle has indicated is that he'll have a word with Mr. Masters and they will decide who's going to deal with
Yes.
landscape, who's going to deal with flooding, who's going to deal with ecology, and who's going to deal with planning.
Exactly.
And
That's
then
my understanding.
either one or other will deal
Yes.
with it. Yeah. Okay.
Yeah. Now, clearly, a revised timetable has been necessary, and one's been issued. There were a couple of points about availability, and hopefully, the revised timetable takes care of that. I think there was a point raised by Mr. Masters, may have been Mr. Rowe on behalf of Mr. Masters, about his availability. I think you had commitments elsewhere, Mr. Masters, next week. So hopefully that's been addressed. I think it's the day for site visits. And I think, Mr. Lintott, the council wanted a move round in terms of ecology and landscape. So that's been
I'm grateful that's been taken care of.
That's
yeah.
been taken care of. Can I just check now? You should have the latest timetable, which hopefully the office sent out, should be version 3.
It is, yeah.
Yeah, that you've got. If anybody in the public gallery and the representatives of parishes haven't got them, I've got some spare copies if anybody needs them. But does that present any difficulties in terms of availability? Good, thanks. I did mention last time that I'd been to Stovolds Hill and seen the various sites before the inquiry opened. I haven't been back, so that's the extent of my familiarity on site at the moment. I will, of course, make a programme of site visits in due course. Whilst I'm on that point, I have asked for suggestions of places that the parties would like me to go to.
So in
I've
anticipation.
no response.
In anticipation of that, Inspector, I've asked Mr. Dudley to provide a suggested route for your site view, and then we'll circulate that to all the parties so we can agree that.
Finding out who's going to be chief of this woods. I'm trying to accept your view.
Mr. Masters, each of the sites is on the north side of the access track to Lidger Park. They're all in a similar position. C and D are a little bit further back, but they're no further back than site B in terms of their relationship. The bulk of the evidence, although on both sides, parties make reference to there being 4 separate appeals following 4 separate applications, the bulk of the evidence is the same, whether it's in terms of flood risk or landscape.
It straddles the road, balancing the western side. Whereas the others are clearly on the outside.
C and D do as well.
C and D are clearly on the outside. No, they don't straddle the road.
Yes, they do. On the top.
They're on the outside of the boundary road with the whereas in fact, Simon Lockwood's site is straddles the road. It's where the road stops.
By straddles the road. Are you suggesting that
It's the red. It's the red edge, Mr. Linton.
on CW6 we've got the plan?
It's straddles the road. It's not where the road is, but where the road could went there.
It goes over the access track, but so do C and D in terms of the red edge.
Yeah.
No,
They do.
C and D are buying other access track, but they're not buying the access track.
The red edge for C and D extends all the way to Stovolds Hill.
Well,
I don't want to.
I haven't seen the plan, but that's not where the sites are. Not on the plan.
I know the pictures are further back, but the red edge, which is the application and now the appeal site, includes the access track. That's how it's been drawn. That's how it's been submitted and considered.
That's only taking account that particular access track, not the next. I wonder whether I don't have a plan.
It's the one that you said that you had an input into drawing. This one at CW6. That's the one the inspector was holding.
Can you
up.
just show me that, Mr. Linton?
That's the one, isn't it, Inspector?
Yeah, yes, it is.
Yeah, of course.
doesn't straddle the access site, so it isn't to the east. Whereas in fact, the line must be the only one gone. Certainly arguing that with certainly not following on within the near the access track. But the point is, the red line is drawn not because we overlap, because of the access point.
The point is, I'm just looking at the site plan for site B. It seems to me to be the same arrangement as for C and D. The red edge extends onto the track, but the pitch proper is clear of the access track. I don't really want to get involved in any more detail on this at this moment, Mr. Masters. Have a discussion first of all with Mr. Cockle during the lunch adjournment, and come back to me if you really need to when we resume this afternoon.
I don't think we can change that.
Well, I want to have another look at what Mr. Woods has put in and how he's addressed it.
Chris, could you?
I would only just draw to your attention that Mr. Dudley clearly draws a distinction in terms of that landscape and visual impact between the sites.
Yes, he's put in
Yeah.
separate evidence.
Yeah.
Correct. Yeah. Okay. Right. Plans. Got those. There was a recent communication from the local planning authority, I think, Mr. Lintott, about the statements of common ground, saying that from recollection, I think the council said that it had prepared a draft and sent it to the parties, but not got anything back. I've certainly not got anything.
Yeah, well, there was quite a long gap following the last inquiry where there wasn't a response, and then we did get a response back, and then we've sent that back. Unfortunately, when it came back about a week ago, or just over a week ago, one of the council's witnesses was on another inquiry, so it then took a couple of days for him to come back, and so I think it was about a week ago that we went back to the appellants on that. So I haven't seen anything on this draft. I've got copies of the latest draft in front of me, and as will you have, but I've not seen a response to that. I would just say that in respect of the latest draft, and paragraph 4.3, which is the list of traveller permissions, we've noted that there is actually there are actually two permissions that aren't included on that from Mr. Jarman's paragraph 89. So in actual fact, that table isn't entirely accurate as it stands, but we'll be going through that anyway very shortly. So I don't think we're going to agree that in advance of the round table. But the rest of it, we ought to be able to come to some sort of agreement. I
Yes.
thought.
Well, I think the thing was, we sent it back to the local planning authority as to what we were saying in terms of statement of common ground. There's lots of matters in there that we don't agree to, and we're not going to be agreeing to. So we have two versions. As I said, I needed to discuss it with Mr. Rowe to make sure he's happy with it. And we propose to sign our version, and the council have sent over to us a signed version of their version. And we have a document that shows where the changes are, so highlighted in yellow to make it easier for you. But you know, we're certainly not going to subscribe to what the council have put in terms of a statement of common ground. It's just not acceptable, sir.
Well, I anticipate that, and it'd be unusual if there weren't outstanding areas of disagreement between you. But I anticipate also that there will be areas where you can agree, where you should have been able to draw up a document, particularly given the length of the adjournment.
I totally agree, sir. We put an uncontroversial document back to the local planning authority, and then they added in lots of things that they'd had before. So, you know, matters of evidence, you know, uncontroversial matters, agreed matters should be able to go in there. And I think the documents will speak for themselves. You'll be able to clearly see where the local planning authority want to insist on us signing a document that we're not prepared to sign, sir.
Right, at this stage, I haven't seen even a draft, so
No.
uh,
Right,
I,
Inspector, what I would suggest is
I'm
just.
not sure in view of what I've heard, how useful that's going to be.
If we've got two versions, that won't be useful. I suggest that what Mr Woods and Mr Rowe do is just move anything that's not agreed from the agreed section into section 13, which is matters of
Well,
disagreement.
so I suggest rather than that, that the uncontroversial version is used, and if the council want to add anything, they can put that in the disagreed section rather than in the agreed section.
I think
So
that's what
then it's-
Mr.
what I
Wintott's
said.
just said that.
Well, no, he said he's putting the onus on us. We're suggesting it should be on them. We've sent a complete uncontroversial version, which they then decided to edit, but not in a constructive way, but in a destructive way. So all they need to do is to put their edits that they put into the uncontroversial into a section marked not agreed. So I'd ask them to do that, sir. They have the document, they can do that.
Well,
Well, we need to see the new version first. If we're going to do it, we can do it. I mean, just to be clear, what we tried to do was to isolate a series of definite facts that could be agreed in terms of things like receptors and visual viewpoints and that sort of thing, which should be a matter of agreement in terms of whether or not those exist or not, and put those into matters of agreement for you. If those really aren't agreed, then we will need to take out those elements and put them into the disagreed. And obviously that will guide the cross-examination on those topics. But at the moment, the first step is we need to see back what Mr Woods and Mr Rowe have come. And as I understand from what Mr Woods is saying, he needs to speak to
okay,
Mr Rowe.
well,
on that.
Sent it to the council. They've seen it.
right, Mr Woods, from my point of view, it doesn't matter too much about the in terms of the mechanics of moving points that are disagreed from one section to another. But given where you are on this, can I ask for it to be completed in a form that you can agree on in terms of what's agreed and what's disagreed by tomorrow?
It would be very helpful if the planning authority took the document that we submitted and then put all the extra points that they wish you to add in that we haven't agreed in the list of unagreed matters, and we'll look at the plan, the paragraph 89 point, and get that agreed with you.
Well, I mean, my understanding of where we are is that we've sent a document about a week ago across to the parties, and we haven't had a response back to that document. So some sort.
Well, I think you're getting the response now, Mr. Lintott, that the changes aren't agreed. So
we will need just to take all the
just take them all,
changes out, put
take
them
the
in
changes out,
disagreed.
put them in a section called disagreed, show it to the appellants so that it can be signed, and let's get it in tomorrow.
Yeah, I think that's what we need to do.
But I do hope, given the indications that there are large areas of disagreement, that when we come to examination, that I suddenly find out that points of matters of fact are in fact being agreed, and that I hope that we're not going to have unduly long cross-examination because of this.
Well, you'll find out when you go on your site visits and you struggle to look for the appeal site whether or not we should have agreed it. You'll be able to decide that.
Well, that's just one area, Mr. Cocker, isn't it? Landscape. Okay. Well, I'm hoping that you can deal with that by tomorrow morning. Statements of common ground. Okay, we've talked about this in some detail. The other thing that I wanted to check was hopefully an agreed list of suggested conditions. What's the position on that?
There's a little bit of work on our behalf being done in relation to flooding, because there was supplementary evidence, might have been served earlier, but it was served in May, as I understand it. And we are hoping to deal with that new evidence on flooding by way of a revised condition. So I've spoken to my own friend on this, and I've indicated that we should be able to provide him with something before the flooding evidence begins.
Does that mean, Mr. Cottle, that progress has been made on other matters subject to condition? I mean, is there a draft list that I can have, which apart from the matter of condition of flooding?
Yeah, we sent across the draft. I don't know, a long time ago. I don't know how long ago, but I mean, you can certainly see that. I mean, that we haven't received any notification that those conditions are agreed. But and Mr. Cottle did tell me about a new condition on flooding this morning, but
Yes.
I've not seen that. I've asked for a copy of that, what he suggests.
Right. So there's been no agreement on the draft list. I think in terms of that, I could do with seeing that draft list, Mr.
Yeah.
Lintott.
If I could ask on behalf of
Mr.
all
Wood,
the
yes.
all the appellants, if we could at some stage have a printed version of that, the conditions, that would be
Right.
helpful. And then when we've got adjournments, we can deal with it and
I
try and have
pre-
it smoothly go through.
Mr. Lintott's saying it's been sent to the appellants. So you should have it, Mr. Woods.
I've asked for a printed version, if I may, sir, through you.
Appendix 1 to. So it's Appendix 1 to the statement of case, as I understand it. That's just the latest one.
I've asked for a printed version,
know you have,
please.
yes.
Yeah, I'll repeat what I say. I've got these things electronically, but I'd like to have a printed version to speed discussions on it. Reasonable request. If they don't want to provide it, that's
Right. Okay, well, that'll be up to the local authority. I'm sure they've sent it to you some time ago, Mr. Wood. You'd have had the opportunity to print one off.
thousands of pages of documents, sir.
Yes,
Try not to bring too many.
of course.
So, apologise.
Yeah. Yes, okay. I'm sure the council will do what they can. Next thing on my list of documents is planning obligations. And I think, Mr. Cottle, you suggested in November that there might be planning obligation required in relation to means of access to Site B. Am I right?
I'll have to take instructions, sir. Not something that springs to mind.
Right, I'll just go back and just tell you what my note says. Yeah, I had no advance knowledge of any planning obligations. I asked the question, and I've got a note that you mentioned something about that it was subject to discussion. You were reserving your position, and that it relates to hedges by the road. So and I've heard nothing further since then. I wanted to check whether that was still the case or something.
Now it comes back to me. Now I do
Right.
know what you're talking about. Yes, certainly we'll take instructions on that. Thank you very much.
Mr. Lintott, is that anything that the local planning authority has been pursuing?
Well,
at all?
no. Just been reading the note from last time. So,
Yes.
And trying to decipher my scribbled writing on it. But I've written Stephen Cottle planning obligation, and then boundary to Dunsfold Road and the hedge
Dunsfold
to
Road, yeah.
do with landscaping. I'll say no more. And then something about Dunsfold Road. Would it be unilateral? You asked, and Mr. Cottle said he reserved his position. But we've heard no more since that exchange on the last occasion.
Okay. Right. Okay, thanks. And then supplementary evidence. I've had that, received that from on behalf of several of the witnesses. I think 4 of your witnesses, Mr. Lintott, have put in supplementary evidence.
Yes, yeah, that's right. I think they all have.
Right, I don't think I got it
So-
from one of them. I don't.
Hold on, let me just check that, see I've got that right. So Mr. Dudley has, ORS, have, Mr. Ward has, Mr. Smythe has, yes, but all except ecology. Just so you're quite right, Inspector, yeah.
So it's Mr. Sibbott hasn't.
Yeah.
Yeah, so that's 4. So yeah, so I've got those. From the appellants, I've got something from on behalf of Mr. Woods. I've got a 2-page document. Yeah. And I think that also says that there wouldn't be anything else. It's just that document.
And it does append also, Inspector, there's been a new permission granted at Lydia for 2 pitches, and that was sent across as an attachment with Maloney Friends email. So you will have been able to, I think it's the officer's report that they sent
Yes,
across as an attachment.
that rings a bell. I'm sure I've got that. I've probably not printed that out, but I should be able to access it if we need to.
It
Yes.
was, yeah.
Yeah. Okay, thanks. Nothing from Mr. Rowe. Right. Just good. I'm glad I haven't missed anything. And then there was evidence from in terms of updates from the parishes, which I've received. And again, I think they've been circulated to the main parties as well. In terms of the parishes, I've got the statement that's Councillor Britton referred to that was put in back in November. Now, in terms of statements from Bramley, Dunsfold and Hascombe, I just want to check the position. I've got the update information that was sent in. On the inquiry website, the references to those parishes appear to be what was put in relation to the planning application. So when the parishes come to speak, if you could just check what documentation you understand you've prepared. I want to make sure that I've got what's relevant to your particular cases. So we'll deal with that when you come to speak. And if there is something earlier in relation to the appeal that isn't on the website, I and the parties will need to be aware of that.
I have something speaking there, just refer to the general numbers.
Yes, but that's not something you've submitted yet. No, okay. And the other thing about I think the final point in terms of documents is there were a number of documents, I think about 6 or 7, that were put in on the opening day of the inquiry. I don't think at the moment they're on the inquiry website, or I haven't been able to pick them up. So the council could just check.
So which documents were these? Were they
There was a large bundle
are they
of
physical ones that were given
Yes.
to you?
Yes, there was a large bundle of documents put in by Mr. Cottle on behalf of the client he's representing.
Do you know who you
I'm
gave
sure
that
I'm
to?
sure there would have been a copy given to the local planning authority.
So yes, there was one bundle of documents by Mr. Cottle, which was his opening submissions.
That's right.
You recall it was, I think, material considerations, stroke opening considerations,
Yes.
submissions,
But
and
it-
also some authorities.
That's right.
And then I think Mr. Masters put in essentially a court bundle of documentation as well. So he had a hard copy.
There was
of
a
that
bundle
thing
to do with an
also.
injunction.
Yeah, that's right.
Yes.
So those are the 2 that I can think.
I think I also put some officers' reports attached, but I've got a bundle, I've got a copy.
It was all
and I
in,
can
it was
hand
all
you-
in a large bundle, Mr.
Yeah, it
Cottle,
was
I
all
think.
together.
I've got a copy of that bundle that I can make available for the local planning authority.
I'll quickly go through it, and then you can make sure the council can then make sure they go on the website. There was a bundle from Mr. Masters, opening statement from Mr. Cottle, bundle of authorities from Mr. Cottle, Mr. Rowe put in 2 appeal decisions. He also put in a great crested newt mitigation plan and plans to do with the butterfly issue. There's an opening statement from Mr. Lintott and a statement from Councillor Britton. So I listed 7 documents.
And we need to give them each an inquiry document number.
Yeah, I mean, my usual practice would be just do it chronologically. Let's have a section of have a common section rather than split it into 4 ways for inquiry documents and just number them as they come in.
So should we then call Mr. Cottle's opening ID 1 and then his schedule of papers?
Well, yeah, I mean,
ID
that's,
2 and do
I
that?
started off with Mr. Masters. I must have picked up Mr. Masters first.
Right, okay.
Yeah, so I've simply numbered them in longhand in the way I read them out. So Mr. Masters was 1, Mr. Cottle's opening was 2, his bundle of authorities was 3.
Yep.
Mr. Rowe's appeal decisions were 4, and the 2 nature conservation plans he put in were numbered 5. Your opening was 6, and Councillor Britton's statement was 7.
I'm grateful. Yeah, well, we'll make sure all that's put on the
Yeah,
site.
and if you are missing any, I've got a separate file with hard copies which you can take. They're not written on. You can take away and scan them.
That would be helpful, actually. I'm
Yeah.
sure Vicky would find that useful.
Yeah,
Yes,
I can
yes,
do that.
please, because I don't recall actually ever receiving them to scan on,
Yeah.
but if you could give them, somebody could give them to me,
Yes.
I'll get that done, thank you.
Good, thanks. And then once they're on the website, everybody's got access to them.
Yeah.
Good, thank you.
Could I just point out
Yes,
that
Mr. Cottle.
the supplementary note from WS Planning attached an officer's report, which my learned friend just referred to, in relation to a recent permission on
Yes.
Lydia Park. And we were talking about perfecting a statement of common ground
Yes,
and there being a disagreement because of the table of permissions.
yes.
Can I just
That's
point
not
out
what
that
That's
that
true. That's one
table
of the ones that's
is
not-
missing that recent decision?
Right, okay. Well, I suspect we'll hear more about that in due course. Okay, final point on documents. Been through ones that I had a particular note about. Is there anything else by way of documentation that anyone intends to submit? Mr. Cottle?
I have one authority on the question of the appropriateness of sequential tests and surface water drainage from the Court of Appeal that I've told my learned friend about. And I will circulate that at a convenient moment when I've got it out. I've got a number of copies here.
So
And
that's,
perhaps that could go across with the bundle from you to the planning authority's officer for the,
right, so that's to come in, Mr. Cottle.
that's right.
Nothing else on
No.
it? Good, I'm grateful. Nothing from you, Mr. Masters? Thank you. And Mr. Lintott, is there anything further coming in from the local planning authority?
No, not from us, Inspector.
Okay, good. Right, that deals with the points that I wanted to raise before we moved on with the other items on the timetable. So are there any procedural points, any queries before we may move on, Mr. Cottle? Anything you need to raise?
Only that the discussion I have with my own friend, Mr. Masters, about the appropriateness of dividing up the landscape evidence in chief of Mr. Woods, it's something we might have to return to.
Well, yes, I expect that from Mr. Masters' intervention, and I just want to double check Mr. Wood's proof, because I certainly, what bothers me, Mr. Cottle, is I certainly don't want you both asking questions about the same points, and I mean, Mr. Masters is clearly right. They're separate sites, and their detailed position in relation to Lydia Park and the surroundings is clearly going to be different in terms of points of detail. But there are other points which are common, and which are raised on both sides about them. And I certainly don't want the questions being repeated simply because they're in both sets of evidence. Because if nothing else, it runs the risk of one witness giving different answers. on the same point, which is just unacceptable.
Sorry.
So
We're
the,
both aware of that. So certainly there can be some general position. I don't think will be a problem for either of us, but there are specific points related to site.
well, what I'm absolutely clear about, Mr. Masters, you can't both ask questions about the general position.
No, and I'm not planning to do that. I'm not planning to do that.
For example, if there was, if you both had a query about policy interpretation in relation to what's now the national landscape, you can't do that.
No, and I don't think that.
But first of all, I don't want to deal with it now. We've already talked about it a fair bit. I want to go back to Mr. Wood's proof and see firstly how he divide. I want to check for myself how he's dividing it up. And I want to be clear about which section. If I go down the road you're suggesting, Mr. Masters, I want to be quite clear about which sections of Mr. Wood's proof you're dealing with, which Mr. Cottle's dealing with, and that there is no risk of an overlap.
I think so. Provide enough in a way.
Well, let's come back to it after lunch, and then we can all have time to think about it. Okay.
That's why I'm asking that it be a little bit flexible in how we approach it. If we won't repeat it, and we won't. One of us will do the general and one of us won't. So you'll see.
And I'm going to leave this now, but just before I do, I take it that your only concern is about the landscape. You're not concerned about the suggestion that we divide up the other three. Right. Well, you've said no. I'll take you at your word.
I haven't taken instruction from Mr. Cottle, but I don't sympathise.
The planning balance so obviously includes different personal circumstances.
Yes.
Again,
Yes, of course it does.
It's better talking about ecology.
Ecology and flood risk are the other main two, aren't they?
You said on free stuff.
Well, planning was the other top area, yes, but Mr. Cottle's absolutely right. Personal circumstances differ.
Yeah, that's the problem. So I think.
Well, but ecology and flood, you're not going to come back later on in the inquiry in terms of ecology and flood risk.
I think with ecology and flooding, where generally the impacts are the same wherever you are, I think part of the site. So I don't think that.
So you're happy to take one each?
Subject to anything
No.
Mr. Cottle has to say, I'm happy.
Right, okay.
But I can't speak to Mr. Cottle.
No, well, I take it that Mr. Cottle had already indicated that. Right, well, we're going to move into the general need round table now. Am I right to think it's Councillor Stern on this? Would you like to come down? Because the round table should be what it says, and everybody, it's a discussion rather than a conventional inquiry session. Can you get round the other way, Councillor? There's probably you just find a convenient spot where there's a microphone that works. There's right, so I just want to check first of all who's who I expect to be participating on this. Obviously, it'll be Mr. Jarman for the local authority. I don't now for the appellants, I've got Mr. Woods. Mr. Masters, I haven't got Mr. Rowe on needs.
No, sir, he's not here today.
No, I know you. I was surprised when you said that earlier on, given the.
Unfortunately, he has to do something else.
Yeah, I know.
Was gonna
That's,
be an issue.
see, but, so in terms of C and D, we've got nobody on need.
No, sir, but generally I'm going to rely on the evidence from Mr. Woods.
Because it's the,
Because effectively it's the same issue. I mean, their personal need is different, but in terms of general, the evidence from Mr. Woods, that's underlying.
right, it's not, what's said on general need is obviously different in terms of the documents that they put in.
If you look at Rose's proof, you'll see he's doesn't say much of the need anyway.
Yeah.
It was always our intention to rely on the evidence of Mr. Woods, and I have had prior discussion with Mr. Woods about that. And he's retained. He's not speaking, my client,
Well, exactly.
but
It's, he's not in,
general evidence being in district, the evidence.
well, yeah, he's putting in evidence on behalf of, appellants A and B,
We're piggybacking on that.
but but there's no direct evidence being put in terms of,
No,
all I've got in effect is the written representations on behalf of,
we're relying on the director. I mean, Mr. Royal said he comes back himself. I rely on the evidence he supports. He's not here to say that today, but that's his position. No, I'm saying it on his behalf with around two.
Hmm.
I mean, you did it. I'm sorry, sir. It shouldn't be a surprise. We've tried to be pragmatic, but I think we've been fast. Road could say exactly the same. Because it will be the same. He doesn't need to. He's already said it.
Mr. Winton.
And Inspector, in respect of your fifth item on the little agenda that you circulated yesterday, use of pictures at Lydia Park, you've obviously got Mr. Chris Ward's evidence on that in 16A, I think, of the evidence. So he will be the one speaking to that element. Yeah.
Just highlighted the main areas that I wanted to make sure we covered. There may be other ones. I just want to make sure I include those. And I know a lot of the detail is in the documents that have been submitted. They've got the GTAAs down as a core document, and then the proofs which say varying and supplementary evidence which say varying things about it. But there are certain key things that I want to be absolutely clear about. So I want to try and follow that structure that I set out in the note. So I'll go around the table, seek views, and hopefully the discussion will progress from there. So if we could start with the appropriate approach to assessing need for travellers in Waverley. And I think I'll start with you, Mr. Jarman. I think the first thing I want to be clear about is the base date. And given that we're going to be, I'm sure we're going to be talking about some individual sites and perhaps the dates of permissions, I just want to be clear about that. My understanding is that it's March 2017 for the GTAA. Is there a particular date? It's often the 31st of March in these things. Is that, like, I couldn't, that wasn't immediately springing out at me.
That would be a fair assumption to make, sir, because that would align with the financial year monitoring periods the council then progressed year on year.
And so is that right?
That's correct, yes.
Yeah. And I assume that we still work that the position hasn't changed. It's that is still the GTAA, and this is touching on the point that Mr. Masters has
Well,
raised.
so we don't accept that date because
Mr. Masters, just what
yeah, okay, so last.
there's an opportunity to contribute, but it's helpful if I can hear an answer to my question first before. Now, I know Mr. Masters is going to raise the point of any subsequent work on GTAAs, but in terms of the documentation that exists in the public arena, what is the position, Mr. Jarman?
The current position is that the GTAA dated March 2018 is the current assessment of need that needs to be considered as far as this inquiry is concerned.
Well, two points from that. It's dated 2018, but the base date's 2017. Am I right then on the 31st of March 2017 is the base date from which you work forward to look at need and supply? If it's
That's correct, yes. So the assessment runs from 2017-18 financial year to 2032-33.
and 2018, is that just a publication date, or wasn't there some update?
2018 was the publication date. There was a minor update in relation to travelling show people. So it was originally published in June 2017.
Right. So does the later version have any effect at all on gypsy and traveller accommodation?
Not in the slightest, no. It was a minor issue in relation to an ongoing problem with some travelling show people that just needed to be resolved, but bears no issue in whatsoever in relation to the gypsy and traveller.
So if there would comparison of documents from 17 and 18 would show no difference at all in figures for gypsies and travellers. And it runs from 2017 to 2032. That's right, a 15-year period. And how does that period of time, how does that compare with the local plan?
I think that would be a question for the council to respond to.
Is it one for Mr. Ward?
I hadn't anticipated the question, but my understanding was that that was in line with the local plan, but I'll need to actually check a document to
Yeah.
be definitive on that.
Ward will need his microphone, but the plan was adopted in 2018, sir.
I think that I'm thinking of the plan period, Mr. Cottle, whether it runs to 2032 as well. But come back on that, unless you know it now.
Sorry, so I missed your question in there, sir.
Mr. Cottle was giving me when the plan was available. I was thinking more of the plan period where it ran up to, whether it was 2032 as well.
So, Inspector, I can help with that if I may. In paragraph 1.2 of the Part 2 local plan, it runs from up until 2032. So it's a period 2013 to 2032.
2030.
Yeah. And of course, the local plan Part 2 was published in 2023.
And I think you've already told us, Mr. John, that your position is that the GTA is the relevant starting point.
That's correct, sir, yes.
Okay. Just leave it there. I just want to bring Mr. Masters now because he was keen to query this in terms of that GTAA. I just like to hear a bit more, Mr. Masters, about your concern.
I'm sorry, you're right.
Well, you're always keen to participate, Mr. Masters. But I wanted to give the opportunity to, because I think you had another point, perhaps apart from the detail point about the Bay State. And I think this was a point about, is it this GTA or is there, or do we need to know about another GTA?
Well, so
And I just wanted to give you the opportunity to say anything you wanted to about that.
So Mr. Woods will tell you that the council commissioned the GTA over a year ago. He will give you the exact date.
Well, Mr. Woods will
Yeah.
say what he wants to say in
And,
his own time.
We believe that the surveying work has been done and that for some reason it hasn't been published. And you may note that in answer to your question, Mr. Jarman didn't say anything about those dates or whatever. He merely said, for the purpose of this inquiry, you'll be taking the 2017 GTA. So we know it hasn't been published yet, but I think you ought to explore what's been done and why, because of the delay period. Because we are, I'm afraid, sir, rather suspicious that between the delay between the inquiry last time and this time, it hadn't been published because we expected it would have been.
Well, what you're telling me, Mr. Masters, is that you're saying a further GTAA
Yes.
was commissioned over a year ago, so 2024.
Mr. Woods, can you be precise about the date?
Yeah, it's set out in my evidence. So the contract date was the 5th of February 2024
Yes.
to the 27th of June 2024. And of course, we appreciate that the PPTS has been updated in December last year, but in the interim, no GTA was published prior to then. And of course, we've had a number of months since then, and it's still not been published. Mr. Jarman says that this is because of changes to the council's local plan timetable. Well, it really shouldn't affect interviews of those in need in the borough. And of course, the original GTAA, going back to the base date of March 2017,
Yes.
in that GTAA, only I think it was 40% of those were interviewed. So it's woefully short on interviews in any event. So you could exclude lots of households that have got likely to have newly formed households with teenagers, etc. That's why it's generally accepted throughout the country and by inspectors that GTAs shouldn't have a lifespan of more than 5 years. So what we've got here is a very outdated assessment, relying on things that are not robust enough. And the point is, you just have a snapshot in time, and I know it's only a snapshot in time, is caravan counts. And currently there's about 100 unauthorised caravans in the borough. So, you know, all of those people should be interviewed by Mr. Jarman's company, or a high percentage of them, because the council will know where these unauthorised sites are, and deal with it in a proper manner. What's happened is the can's been kicked down the alley, sir. We haven't got an up-to-date assessment of gypsy and traveller need in this borough, and it's a failure of policy. And really should have been addressed. There's been plenty of time for it to be addressed. It's crucial in the consideration of these appeals,
Yes.
sir.
So the point I adequately made just a moment ago is that very little reliance can be placed on the last GTA because it's
No, that's going into a different point.
okay, but it's
What I want to know about is, because you've raised the position of the further GTAA, I want to be clear about what the appellant's understanding of that that is, what your knowledge of it, not what your supposition is, not what you suspect had happened, or what is the fact that I've got so far, and Mr. Jarman will have an opportunity to confirm this if it's correct, is that Mr. Woods says, and I've written down the dates, that there was contract date 5th of February 24 to the 27th of June 24. Now, what was your understanding? Were you telling me, Mr. Woods, that that was the period during which work started and was completed and published? What does that period mean as far as you're
Well,
aware?
that's certainly my understanding. It was on the council's website at the time when I wrote my evidence. So
That in just over 4 months, the whole exercise will be done?
yeah.
I would just like to throw in before Mr. Jarman comes back another point.
Yes, Mr. Cottle.
According to Mr. Ward's supplementary proof CW16A, there are a number of pitches on Lydia Park, which the local parish councils also speak of, where statics occupied by policemen or doctors are advertised on the open market. And in those circumstances, Mr. Jarman's GTAA has had a problem in dealing with these, what I would call site subject to a question mark, where the number of statics exceeds the number permitted. And one wonders whether the permission actually lapsed for those sites because they've never been implemented according to the plans. But the point that Mr. Jarman has to deal with is that he's here to assist the Secretary of State reach an informed decision. And he knows what he's already done and what he's already interviewed and how far he's already reached. And a proper authority, properly directing itself, would come to this inquiry, telling you what they've done so far, what results they've got so far, but they haven't been able to complete it because of these problem sites.
Well, Mr. John will no doubt tell me what he's able to in a moment about that, Mr. Cottle. Just want to go back to the further GTAA and exactly what the appellant's position is on it. So your understanding, Mr. Woods, is that there's going to be a review GTAA undertaken last year. You're expecting publication by summer last year. That's from the publicly available information. That's what you're telling me. And are you saying that is it unusual for GTAAs from start to finish to take longer than 4 months? I think there are several references in the evidence for them to take quite a bit longer than that.
I think from the evidence we've had on other authorities is that it would never take longer than a year.
Never.
Never.
So even recent cases where where there has been delay, because we were cross-examining Mr. Jarman only a week ago in relation to site in Surrey, where there are exceptional reasons for the delay, but the interviews had been done. The delay was had arisen because of the change in circular and information that they wanted to disclose. But more importantly, in that case, because Mr. Jarman was subsequently contracted to do a site allocations type arrangement, review his information so that he could say which sites in the district could be expanded. And so there was the delay, not because they didn't know the numbers, but merely because he was going to attach this new document. But we've had no information or evidence here about anything as to why there might be a delay or anything that's just singly absent. So that we were anticipating the GTA to have been published last year. But certainly from the date it was commissioned, we would have expected it to have been published by now. And so you will have the evidence from Mr. Woods, but of two factors which are relevant. One, he's already mentioned the 39% actually questionnaire rate, which, and if you go back to the London Borough of Havering local planning inquiry, Mr. Jarman's company was made to go back and do that 3 times until they got to 90%, because the inspector found percentages lower than 40 to be completely unacceptable. And they did, and then the need doubled. But the second factor is the more recent GTAs that have been done have been significantly higher in terms of the numbers reached, based on higher interview rates that they're now doing, and of course are based on other factors that have changed from the way that they were analysing the figures. Because it's not because the reality is that the way that they analyse figures today is very different from the way they analysed the figures.
In
2000.
terms of response rate, Mr. Masters, what are you relating that to? The existing GTAA?
Oh, sorry, I can tell you that straight away. If you go to
No, but what context are we talking about now? No,
it's the existing GTA. So if you look at the if you look at the numbers of
yeah, I haven't moved on to the existing GTAA yet.
if you look at figure 7 of the
No, I don't want to go. I don't want to go there yet. I just,
Okay.
But
it basically it's
I want to stick with your concern about the new GTAA.
yeah. So we expect the new GTA to be to response on the new GTA to be much more in the 80s and 90s, and therefore
What
to give
you think it is?
well.
Well, I've been told all you know about it is that it's not out yet, and it should have been out last year.
Yeah, I'm only going on, sir, what ORS have managed to achieve in other districts, which have been mentioned in the evidence of Mr. Woods. But the response rate now is much higher. And we're seeing...
I'm not sure what you're telling me, Mr. Masters. So you're saying that you have information that there's a higher response rate now, but it's still not been published, or not?
No,
what information do you have about the new GTAA, in addition to what Mr. Woods has said?
None, sir. The evidence, we're just going on a comparison more of other GTAs in neighbouring districts. And that evidence has been included by Mr. Woods. And so by looking at how, what ORS are achieving now elsewhere, and for instance, what they achieved in the recent decision that I was talking about a few moments ago, in which district was that? That's...
We can only go on what Mr. Jarman has told us in his supplementary proof as well.
Yes, yeah.
Yeah. So the point that we're making, sir, is Mr. Jarman has said very little. He hasn't given us any information about whether this has started, how far he's got.
Well, I'll give him the opportunity to do that in a moment. And if you wish to come back in it, you may.
If this was a cross-examination, so on oath, those are the sort of things I'd be asking him.
Sure they would, yes. Sorry?
How many interviews have you done?
When did you start? When did you finish? Why is there now a delay?
And do you have any knowledge at all about the delay? About why there is delay? Any understanding of that situation?
Well, so we think it's tactical because of this inquiry.
The delay set out in Mr. Jarman's supplementary evidence.
Yes, I know.
It sets it out there and it acknowledges that it should have been completed by the end of June last year. And then goes on to say that, because it's because of a number of issues, determine accurate site and yard baseline. Why? It should have been provided to ORS before they started their study by the council. And then challenges encountered in initial attempts to complete households and interviews and sites in yards. Well, if it was due to be completed last June, why are we now a year on from the completion date and still nothing's been published? Bizarre. And then changes made in February this year to the council's new local plan timetable. Well, with respect, sir, it shouldn't make any difference to a standalone document assessing need within the borough. And changes to the PPTS definition made in December. Well, we're 6 months on from that. So no real reason why it shouldn't be done. And of course, what should be included was all those households in bricks and mortar, which can easily be addressed by looking at census data. census data sets out those persons meeting or falling within the definition, gypsies and travellers, in bricks and mortar. So they should be all included unless they're interviewed and found that some no longer have a requirement to live in a caravan, which is their cultural need. But if there are some, there may be some for various reasons. The issue about sites being occupied by non-travellers. Well, do we know whether those persons,
Well, yeah,
whether they, have a desire to live in a caravan? That's their lifestyle. We don't know. But there's been no information published whatsoever. So there could have been a partial report prepared to assist you and to assist others in the borough. Nothing has been published whatsoever. The reasons that have been set out are strange. And then it says, goes on to say, it led to the work on a new GTA being temporarily put on hold.
So we say it's tactical because,
yes, you've already said that,
yeah,
Mr.
I
Masters.
know, so, but, so that, and our main concern is that, you finish this inquiry and then it's published with a huge need. And then and there's very little we can then do about it because of course we'll be stuck with, if we were to lose with the position, oh, well, the inspector has dealt with all these issues and now we're not going to allow
Okay,
a new application because of section 70A.
right.
And so that there's a real danger here of injustice and us being shut out some future date with new information, being able to validate a new appeal because the council will say, oh, it's all been dealt with and it was discussed.
Yes. Okay, thanks, Mr. Woods, Mr. Masters. Mr. Jarman, I'm going to come back to you now as well on the same topic, the new GTA that's underway. The first thing I want to ask you about is the time span that was anticipated, and in terms of the dates that Mr. Woods mentioned, February to June last year. Is that correct? That was the original intention, to complete the study within that time period?
Yeah, I mean, that's what's set out in my statements, that we were appointed at the beginning of February and the original anticipation was that the assessment would be completed before the summer break in 2024.
And by complete, does that mean the report produced?
The interviews completed and the analysis completed. Not necessarily a report, but obviously with the travelling season kicking off around sort of late June, early July, we wouldn't seek to be completing any more household interviews if possible. And we would then would have used the summer period just to sort of fine tune the reporting.
Did you have an anticipated report date for publication?
No. It's nowhere near complete. And I think that
When you were appointed, didn't the council expect the report to be published by a particular date?
they request a preferred time period, but that's always up to discussion in terms of changing it.
What was the original intention?
The original intention, as I set out, was that the fieldwork would be completed by the end of June, and then a
Yes.
report would be completed thereon after. But
Well,
as I said,
after is a very long period of time.
thereon after, in some cases, I mean, Mr. Woods, Mr. Masters said that they're not aware of GTAAs ever taken over a year. I've had some that have taken 3.5 years, depending on the complexity, changes of circumstance, etc. So I think that the initial commission was as set out, but as I've put in my proof, my supplementary proof and my rebuttal, things have moved on since we were appointed in
Yes.
February
What
2024.
I'm trying to get at, and you can tell me again about what you say changes circumstance. When did you originally intend to produce a report to the council?
Summer 2024 on the commission and on inception, but obviously things.
Right. So a moment ago, you said that interviews completed and analysis undertaken by summer 24, and the report thereafter.
Yes. So we would have expected a report to follow the field work and be,
How quickly?
well, how long's a piece of string? I can't say a date. It
No,
depends.
but once you've got all the raw information and it's simply, and you've got the analysis done, which you expect to do by June,
In
presumably
some
then you can
cases,
have you must have an indication in terms of your work programme about when you hope to have that delivered to the council.
in some cases, it can take a couple of weeks. In some cases,
Yes.
it can take a couple of months. Every local authority is different in
Of
terms
course.
of the people that need to review a draft report. In some circumstances, as a local plan evidence base, it would simply be planning officers. In
Yes.
some local authorities, it would involve senior officers. In some local authorities, it would also involve members. And in some local authorities, prior to reports being signed off as an evidence base, they go through full council approval. Every council is different, so I can't put a precise timeline on what I would have
No,
anticipated.
I understand that, but would you have expected, for example, to have a report when you were setting out in this exercise to have it done by the end of last year?
When we set out for this exercise, I would have anticipated a report by the end of last year. But things changed.
You've obviously heard the concerns that Mr. Masters has expressed about the delay. You've made some points about that in your supplementary proof on page 4.
Yeah.
Is there anything further you want to say about those?
We did the previous assessment for Waverley several years previously, and things have changed considerably since we started the new assessment. And in the main, in relation to what I will call the wider Lydia Park, Weeping Willow, Yellowstone appeal site area,
Yes.
where there have been significant permissions and there are significant issues with the uptake of those permissions. So that affected our initial timetable, and got a project director, but I've got project managers who are in regular contact with the council in terms of the fact that the field work, whilst moving forward, was progressing at a rate that was a bit slower than we were anticipating because of some of the complexities.
Is this your first bullet point? So
That's the first 2 bullet points, the complexity of actually working out what was what. Not the baseline, because we had the planning permissions, but
yes.
actually working out and articulating what those planning permissions meant on the ground.
Was that not something that you'd encountered in 2017?
No, because there was nothing north of the Lydia Park site, the old Lydia Park site in 2017.
Things have changed in the intervening period.
Things have changed in the intervening period north of what I would have called Lydia Park back in 2017. So as I said, you've got Weeping Willow, you've got Yellowstone, you've got the various other new Lydia Park sites, and then you've got the appeal sites. But I want to go back to a point that Mr. Woods made, and I think this is actually critical, and it's the most critical point. It was agreed with the council that we weren't where we needed to be by mid-June, July, and that there was no point in using limited.
That's this year.
Last year.
Sorry, last year.
Last year. And given the budgetary challenges that councils have, there was only a limited number of fieldwork days set aside for this project, and they were reluctant to use those over the summer months when the likelihood was that people might not be there. So the decision was taken to halt the field work until September, after mid to late September, after the summer period. At that point, we were made aware by the council's planning policy team that councillors and senior managers were considering a change to the council's local plan timetable and were in the process of updating their LDS, their local development scheme. So, and this is the critical point, and Mr. Woods disagreed with it and didn't put any weight on this, but I think this is the most important point you need to consider here. The council's LDS will set out the emergent issues, Reg 18, Reg 19, timetable for the local plan. And in their view, prior to going out to consultation and to actually preparing their local plan policies, their allocations and the like, they would like a GTAA that is as up to date as possible. They have limited resources in terms of commissioning extra fieldwork, so the decision was taken to put the GTAA fieldwork on hold until the LDS had been firmed up and until there were firm dates for the Reg 1819 consultation. So as of the cessation of fieldwork in early summer 2024, I think we were up to about 50% of completed interviews. There is no interim analysis because I'm not completing an interim analysis based on a 50% response rate when there are 50% of sites that had not yet been visited. So we are now in a position when the council confirmed to me when they are planning to go forward to their Reg 18 and Reg 19 to use the remainder of the fieldwork time to complete a GTAA that is up to date as of the consultation on the new local plan. So this is why that LDS point is critical, and Mr. Wood seemed to make a mockery of the fact that that was an issue. I think it's the most important issue that I've put in those points.
So if I could intervene.
Well, hang on, Mr. Masters. Let me just want to make sure I've got down properly what Mr. Jarman said. Right. So there was a delay by last summer. You knew about that. You decided to halt fieldwork initially until September, you said, but I take it nothing restarted in September.
No, because in the autumn period, that's when the council informed us they were reviewing their LDS.
Right.
they-
So originally it was a few months delay,
Mhm.
which has been extended.
Yes.
Right. So, right. So at that time, last autumn, you were told about the change in terms of the LDS. And until that position was resolved, what you're saying is that it didn't make sense from your point of view to complete the fieldwork.
It didn't make sense from the council's point of view to complete fieldwork and then in a very difficult financial situation facing local authorities to then have to identify additional funding to revisit that fieldwork potentially later this year.
Right. So where are you up to now? Has that point been reached yet? Where you?
No, we're still on hold, having completed 50% of our fieldwork days. And we're not in a position to even consider a interim analysis of need.
So is the exercise in abeyance at the moment?
The exercise is currently on hold.
Because of resources.
So that, if I may say so, is totally illogical, because what Mr. Jarman has told you is that they've got the resources for 50%, and then they put it on hold for the LDS position to crystallise in some way, but with no date for that. So that because they wanted the most up-to-date information, which basically means when they restart, they'll have to re-interview everyone. So,
Oh, Mr. Massey, yeah.
in terms of resources, they've just actually made it much more
Well,
expensive.
I was going to ask that point. First of all, where's the LDS up to? Have you got a timetable that you can fit the GTA work to?
I'll be honest, sir, it's very unlikely that we would start any new field work now or to resume field work until the autumn of 2025.
But is the LDS point resolved in terms of timing?
I am not sure, other than the changes were made in February 2025. And
To the timetable?
to the LDS, I understand. And we've not yet been.
Perhaps Mr. Ward can check that and look.
I need to look, so
Yeah, no, I don't expect it now, Mr. Ward, but perhaps you can come back on that.
And I suppose that the key issue here, sir, is I can't just drop everything and drop a fieldwork team back into Waverley next Monday. We have ongoing commitments.
I understand that you
Yeah.
know, you've got work going on elsewhere.
It will need to be reprogrammed because obviously we're kicking off Appleby this weekend. And then the travelling season will move through into the autumn. So that would make sense in terms of resuming. And to go back to Mr. Masters' point, we do collect contact details. So for those sites that we have interviewed, we will be able to go back at a very limited cost and just phone them up, WhatsApp them and say what's changed since we spoke to you 12 months ago.
But are you currently anticipating restarting this autumn?
I'm hoping to restart this autumn if it fits in with the council's consultation on their new local plan, or to inform the consultation on the council's new local plan.
But you haven't, I think what you're telling me is you haven't been formally advised of that local plan position, whether that's been resolved yet.
No, and to go back to the Tandridge point that Mr. Masters has made, depending on the emerging outcomes when the fieldwork is completed, Waverley as well may consider commissioning a pitch deliverability assessment to inform their local plan allocations.
Mm.
And again, different councils work in different ways. Some will publish the GTAA and then the PDA.
Yeah.
Some, like Tandridge, will hold on and publish the PDA as part of a wider GTAA and allocation document. And
But
again,
if the main reason for the delay, well, the second point was to do with the local plan,
yes,
and it's not quite clear if that's been resolved, and we'll wait for Mr. Ward on that. It may be that you're not looking at restarting in autumn.
as far as I'm concerned, the field work is 50% complete. There's 50% budget back, and we await an instruction from our clients on
Yes.
when to resume.
So you could be in a position to restart in autumn, but it depends on the client.
Yes. I have field work resources I can deploy to Waverley in the autumn.
Through you, sir, just at this moment.
Yes, Mr. Cottle.
If it would be possible for you to ask the local authority if it went to a meeting, if there were minutes of a meeting that showed that they were weighing the pros and cons of having a GTA and a new plan, because one can see the convenience of adopting a new plan on the heels of a fresh GTA.
Yes.
But one also knows that there's a statutory duty to review accommodation needs.
Yes.
And this one hasn't been done since March 2017.
Yes.
So the considerations there was that we don't want to pay for actually discharging our statutory duty to review needs. We prefer to put it back, and so we can use it and for the adoption of the new plan.
Yeah.
And in those circumstances, there should have been an officer's report and a minuted discussion where that was considered properly and informed on a legal basis, aware of their legal duties.
So the implication, if I may say so.
No, hang on, Mr.
Sorry.
Masters. Do you know, Mr. John, whether there was anything of the nature that Mr. Cottle's referring to? Because I think that would be useful for the inquiry to see.
No, because this is local planning evidence base, and it was a discussion between myself and officers. There were no officer reports, there were no formal decisions. It is just how this type of work progresses in some cases. And I, as the contractor, take instructions off my client.
If you did restart in autumn, or even at a later date, what about the point which Mr. Masters raised, which I was going to ask you about in any event? You'd have, if you're going to do interviews with households this year, but you've already got 50% done, I think you said. You've got information from different base states, haven't you? Would you not have to go back to the original ones to ensure you had a common base?
Yeah, I answered that question a few moments ago.
Yeah.
We've got contact details for the
So you
people
would
we
need to
have
go back.
interviewed, so we would just get back in touch with them and seek to ascertain if there've been any substantive changes since we spoke to them 12 months ago. But it wouldn't necessitate sending a fieldwork team to revisit the households on site.
Okay.
lot can change in a year, and there is no guarantee that there'll be the same people there, and therefore a team will need to go back, no doubt, to double check any people that have come since and people that have gone.
I disagree with that, Mr. Masters, because if we phone up and say, Mr. Doherty, we interviewed you on site X last year, and then are you still there? Yes. Or if they say, well, we're not there anymore, then that may necessitate, can you tell us who is there now? So
He says you'll have
Fine,
to go
so-
back. You'll have to go back and check.
yes, so in that case, when we do go back to complete field work, hopefully in the autumn, there will hopefully be a very small number of sites that we may have to add to that revisit list.
Yes.
Could I also ask through you, sir, whether or not Mr. Jarman was in a position to look at waiting lists and those in bricks and mortar wouldn't necessarily be affected by the problems that Mr. Ward refers to in his CW 16A regarding what I call these problem sites, which seem that the planning permissions were never implemented on.
In terms of waiting lists, I mean, we've got a very good relationship with the managers of the public site at the Willows in Runfold. And as a matter of course, we would arrange a 30-minute Teams meeting with the site manager just to get the most up-to-date situation in terms of the residents of the site as close to the completion of the analysis as possible. And at that point, we would also seek to determine any issues in relation to the waiting list. So that's something that we leave until the very last point, because I think that's one site we have completed interviews on all the pictures, and we would just seek to review that as a matter of course 12, 18 months down the road.
So it would be possible for the local authority to present the emerging households and the waiting lists and the existing residents in relation to its council site. Would be possible for them to do that in relation to the sites that were authorised by the appeal decision of David Murray and by Inspector Ashworth on Lydia. It would be possible for them to do it in relation to the, what I say, less fluid sites, or the permissions which aren't subject to the question marks in 16A, where the interviewers ran into a problem because they found a number of statics, like 32, on a pitch.
I think the problem here, Mr. Cottle, is we're getting into a very dangerous situation in terms of data protection and GDPR. And whilst there may be personal statements that have been submitted for a number of the applications and appeals that have been allowed in Waverley since the last GTAA, we would technically need the express consent of the persons that made those statements or of their advocates in order to use that information to support a GTAA. Now, if people are able to confirm that that is acceptable, but we've got a very cautious information security team in my office that are very careful about what information we can and cannot use as secondary information. But yeah, I mean, in an ideal set of circumstances, if we're not able to complete interviews for whatever reason, we would seek to get proxy information from whatever sources we can, because some information is better than no information.
Yeah. Okay.
Sorry, I
Don't
wonder if
think
I
it
can
answered-
go. Sorry,
Don't
Mr.
think
Paul.
it answered the question at all, but they do know what the emerging households are from those sites that I referred to, and they could tell you.
So that to make the point in another way that Mr. Cottle has just made, and embellish on the tactical point I was making, is that what you know is that a year ago they surveyed 50%, so they would have got by that a very good flavour of the numbers. And then we're told nothing to do with the numbers, but for an entirely different reason they stopped. And we're told there's no officer's report, no formal decisions, no report to council.
Yes, I've heard all that, Mr. Masters.
And so that leads us into the suspicion that the stopping was more to do with the survey results where they'd got at 50%, which they are not disclosing for you, today, and for which Mr. Jarman has set the scene, but he's not doing it because of data protection reasons.
Mr. Masters, I mean, I just want to make the point here. We've done 50% of the field work. We've done no analysis. We haven't processed the forms yet. I have no idea what the emerging need is. You could have me under oath, under affirmation. I would give the same answer. It hasn't been done. I do not know. When the field work is completed, my data processing team will process the forms.
Yeah.
Then my analysis team will complete the analysis. Then I will review it and have an emerging set of need figures.
Yeah. So
They are not in
okay,
existence.
that I may say, so the numbers are the numbers, sir. He'll know by the trends in the numbers where the trend is going to be. Mr. Jarman has been doing this job long enough. to
Yes, I
that.
know. I think we've had a pretty good session on where the council is up to with the, and ORS are up to with the work on the new GTAA.
Could I ask that the council does take instructions from its department as to the officer who authorised Mr. Jarman and his team to stand down in the autumn of 2024, because it was decided that rather than spend the money on completing the GTAA, they'd wait and use their money at a later moment in time for the purposes of the new plan, because that decision must have been taken.
So I was going to go further than that. I was wondering whether or not you could request that officer attends and gives evidence, possibly under oath. Because as I said, there's a question mark as to whether that's accurate or whether it was tactical. And I think this is pivotal to any decision you may make.
I would
Mr.
say
Lintott, do you want to
exactly-
come in?
Yeah, I would just say exactly the opposite. You've had extremely detailed and candid evidence from Mr. Jarman, who's the person responsible for pulling it all together, on what the detailed reasons are for why it's taken such a long time. There are the reason that he's identified. There's the other reasons that he's put in his rebuttal evidence. There's been a changing situation in respect of all of those matters. I mean, I must say, I do find it disturbing to have it continually suggested that there's some agenda, or Mr. Jarman knows things that he isn't letting on, when he's given you a very clear answer on that on several occasions. He runs an extremely large organisation with lots of teams of people, all given particular topics and all looking at instructions to deal with data analysis, and he's explained how that works. And in my submission, you've got that information to form a view as to what the cause of the delay is.
Yes, I've had detailed participation from all of you on this. I want to draw the session on the forthcoming GTA to a close. I'm not going to take up your invitations on that point. I'm fully aware of your concerns, and I've noted those and noted Mr. Jarman's answers. But before we move on, and I'm looking for a break now because we've been sitting for nearly 2 hours, Councillor Stern, you've been listening to all these exchanges, and I think the parish council have a particular point which we're probably going to come on to later on. But I just want to give you the opportunity, if you have one on behalf of the parishes, if you have, you may not, but I just want to, if you have anything you wish to say about the 2017 Gypsy and Traveller Accommodation Assessment, I'd like to hear it.
Okay, thank you. Because I'm new to this, I'm not quite sure what is totally relevant and what is not.
Well, if it's totally irrelevant, I'll tell you.
Okay, one thing in support of Mr. Jarman's statements regarding difficulty of the GTAA assessment, local knowledge, outside travellers are invited in by somebody from Stovolds Hill, because we had a bunch turn up on a green outside our parish, and when asked what they were doing there or how long they were going to be there, they said, oh, we're just waiting for the new pitches to be available up at Stovolds Hill. I think they'd come down from up north somewhere. Mr. Masters referred to numbers trends, saying, oh, well, given the trend, it should be possible to say where it is going forward. And I'm saying if that trend continues, it's totally unacceptable, because the number of traveller caravans in Waverley has more than doubled from the 137 reported in January 2014 to 365 in July 2024. So that's a 165% increase, which is more than 5 times that of the whole of England. And the other point is that in 2024, there were 198 static caravans on the sites in Stovolds Hill.
Right, I think you're talking particularly about Stovolds Hill, aren't you, councillor?
I'm talking generally because when the initial application was approved by John Prescott in 1997, it was just for 22 caravans.
Right,
And that's important in the context of the nearest settled area.
right.
It's
that's
about
a
22
yes,
homes.
I think that's
So
slightly
there was
separate matter.
no dominance. So now we're looking at over 200 caravans, and the settled community hasn't changed. It's still only 20, the nearest settled
Right.
community is still only 22 houses.
Okay, but I just want to
So-
concentrate in particular
Yeah,
aspects as we
okay,
go through
well,
it.
That's my numbers.
Okay, thanks. Right, I'm going to take a break now. When we come back, I want to then go to have a look at the 2017 GTAA, which is obviously the latest one that's available to everybody. And what I'm looking for your views on in that. And and this, of course, is with the caveat of the misgivings that the appellants have about that document. But in terms of its approach, I'm looking for your views on whether that does deal with the relevant components of need, whether there's other areas that should be taken into account in assessing need, putting on one side the question of whether or not you consider it can still be used or whether it's out of date. I just want to, in terms of an approach to assessing accommodation for gypsies and travellers, and then we'll move on from there. So we'll adjourn now, and the inquiry will resume at 12:10. Thank you.